That's right.
All right, time is now 5:30. We'll call the August 9th meeting of Lawrence County Council to order. Begin with an invitation by Vice Chairman Carroll, followed by the pledge of allegiance. All those who are able to stay.
Pray with me. Dear Lord, we thank you for your rich and many blessings. Thank you for our ability to be here tonight to discuss Lawrence County. Lord, we thank you for the beauty of this county and the freedoms that we have to live here, Lord. We ask that you be with us as we discuss pertinent information and the decisions that were made are glory in your sight. Lord, we ask your guidance as we do everything tonight, that everything be what it should be for Lawrence County. In your name we pray. Amen. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Good evening. Thank you all for joining us this evening. First up is approval of the agenda. Are there any additions or deletions to the agenda this evening?
Motion to approve the agenda, Mr. Chairman.
Second.
Motion by Mr. Rankin, second by Ms. Clark. All those in favor, please raise your right hand. 6-0. Next up, we have approval of the minutes from the July 26th meeting. Have a motion to approve the minutes.
Motion to approve the minutes, July 26, 2020.
Motion by Ms. Clark,
Second.
second by Mr. Carroll. Are there any additions or deletions to the minutes? And I'll call for the vote. All those in favor, please raise your right hand. 6-0. All right, next, we have public comments. So first, Ms. Stewart.
Good evening, and thank you again for allowing me to speak tonight. I am Susan Stewart, residing in Fountain Inn, Lawrence County. I'm also here tonight as a representative of Lawrence County Residents for Quality Rural Living Incorporated. I visited the Lawrence County Building and Code Department, Permit Department, and the Public Works Department on Monday, August 1st, in anticipation of reviewing the most current plans for the Bridgeway subdivision on Hunts Ridge Road. And I was quite aware that the project is no longer in litigation and expected to be able to see those plans. The plans were not available, and as it was reported to me that the plans were in Mr. Cruikshank's office and that he was out of town on leave. I have not yet been given access to those plans or any information about how I might do so and get a look at these public documents. And I also have concerns that, you know, are the county plans on site in the county or are they off site? Are they under county control and within county property? My reasons for the review of the plans relate to specific plans for the abandoned cemetery on that property for the Bridgeway subdivision, and also the rumored Indian mound burial mound that's also on that site. The cemetery actually sits on top of this mound. Now, council member Diane Anderson and I actually took a visit to that cemetery over a week ago. It's very obvious that the cemetery's been abandoned. But there are approximately 15 plus field stones that are turned up that have marked spots. And there are 2 marked and carved and crudely marked headstones on that cemetery top of that mound. And unfortunately, the lettering on the headstones is illegible. But you can definitely tell there's lettering there, and Ms. Anderson was able to get an opportunity to see the things that I was able to show her. I'm certainly not an expert in that field, but I have reason to believe or suspect that the cemetery contains the human remains of early settlers from that area from about the 1840s and/or sharecroppers and slaves. The South Carolina laws regarding cemeteries include information on abandoned cemetery, and this one is definitely an abandoned cemetery. And the laws also make reference to the handling and relocating of the human remains. Actually, the cemetery laws are quite numerous. If the remains need to be relocated, and that's very common with an abandoned cemetery, it is the responsibility and at the expense of the property owner to have to take care of that for the removal and establishment of the interment of those remains. It has to be supervised by someone who has professional certification or license, like a funeral director or someone who has cemetery experience, to supervise that as that's occurring and to make sure it's being done properly and according to South Carolina law. There are also very strong specifics about handling and protecting the burial grounds or mounds of our indigenous people. And of course, we know in Lawrence County, we have other Indian mounds. And many of us who grew up here have seen evidence of people who lived here prior to immigrants that came to this country. The location of the mound on this property appears to be several rows back into the planned project for a bridgeway. It's hard for me to say. I had to do an estimation on that because the only document I have seen of that project is that one map showing the houses are drawn. But the mound, which houses the cemetery, actually sits right central or appears to sit central in the middle of that planned subdivision. It's adjacent to Hunt Creek, which is a South Carolina Blue Line waterway. And the mound is definitely a defined oval. It appears to be man-made, and it does not appear to be a natural formation. The abandoned cemetery, as I said, sits right on top of the mound. There are trees there now, but those appear to be new. That probably at one time, that cemetery on top, or if before settlers or whomever were buried there, it was probably flat on top with very little vegetation other than some kind of grassy material. Now, someone's been examining that cemetery property, and Ms. Anderson and I also saw that. There are clearly marked multiple locations where I saw flagstones where there is a flag, or there are multiple flags from a ground penetrating radar company. I suspect the developer on the property or the property owner contacted for the examination. And as I said before, I'd really like to see the plans, including the identification of the cemetery on their plan map, and make sure that we're in compliance with South Carolina law. Failure to comply with South Carolina cemetery law, specifically if it deals with remains and artifacts being destroyed or improperly disturbed or removed, is punishable as a felony in the state of South Carolina. So we need to keep that in mind. And I will refer you to a few of the laws. South Carolina Code 1617-600 deals with the destruction and desecration of human remains or repositories thereof, including Native American burial grounds or burial mounds. South Carolina Code 274310 through 274340 deals with the removal of abandoned cemeteries. South Carolina Code 6135 deals with preservation of abandoned and unmarked cemeteries. And Code 2743-310 deals with providing access to cemeteries on private property. Code 1611-780 deals with the prohibition on entering certain lands to discover, uncover, move, remove, or attempt to remove archaeological resources. I would like the assurance that somebody that's qualified and independent, a professional, will be granted access to and allowed to observe the treatment of the site, including that the genealogist or a cemetery expert and or an archaeologist, if those are appropriate for that particular spot. I'm currently in contact with our state archaeologist, Dr. Jonathan Leader, and the South Carolina Department of Archives and History. Both are awaiting information once I'm able to look at the Ridgeway plans, and then they'll see how they might want to proceed with looking at that site. I'm requesting that the laws specify specifics and requirements, land requirements for cemeteries and archaeological and burial sites be included in these ordinances that we're currently revising, and that we make sure that developers are adhering to the law and following those specific laws. Some of our developers may not be from South Carolina. It would be a travesty if the cemetery at Ridgeway is not properly protected or properly relocated. And if we do not do our due diligence in determining the value of the archaeological significance of the potential mound, that would be horrible for Lawrence County. It certainly adds to our history and the value of who we are and the people that even preceded us. Finally, I want us to continue to work on public access to public information. It's very frustrating to come with the expectation that we'll have access and we don't. And of course, you know, that necessitates additional trips, correspondence. Chairman Brown was gracious enough to respond to me on my inquiry about that, and Mr. Cruikshanks also responded on giving me some information related to the company that's handling the development, but I still haven't seen the plans. I want to thank you tonight for listening to me, and I just hope we'll continue to try to preserve and protect our history and save our farmland. Thank you.
I want to thank y'all for the opportunity to speak this evening. I'm Nancy Garrison, a Fountain Inn and a resident of Lawrence County. I'm also speaking to you this evening as a representative of our newly formed Lawrence Residents for Quality Living, Rural Living Incorporated. We very much appreciate the work being done on amending our current ordinances. We thank you for taking the time that you are, but we believe a lot more time is going to have to be needed to actually continue to move forward with development. We believe there are numerous actions regarding growth and development that are not in compliance with Lawrence County ordinances or South Carolina state law, and this puts us all in a very precarious position. Let's talk about our comprehensive plan. We actually learned a lot from the Planning Commission training session many of us attended. At that meeting, Ms. Wargo, our new county planner, gave a great presentation of the many duties of the Planning Commission. We understand that our county administrator, along with our county planner, have begun to work on this. But where is our Planning Commission in this role? Per our own ordinance and South Carolina law, our Planning Commission are the ones that direct our county staff to update the comprehensive plan. It would be nice to know that they actually have a role in the comprehensive plan, as ordinances state they should. Our Planning Commission are reviewing applications for development to make sure they are compatible with our ordinances the land map use, which we don't have at this time, a comprehensive plan, which is outdated, and the surrounding uses. Lawrence County ordinances and the state of code ordinances state this: the commission shall act upon the request of the county council as the matters for consideration and review. The commission shall review the elements outlined by the Planning Enabling Act as required by law every 5 years and shall be updated. I missed the spot, sorry. The Planning Commission shall review the elements outlined by the Planning Enabling Act as required by law every 5 years and shall update the entire plan every 10 years as required by law. The commission must present any recommendations to the county council and shall review only such matters as directed by council. Any recommendations from the commission must comply with the established hearing notices and related matters prior to the consideration by council. Our current comprehensive plan was last updated in the entire plan in 2010. And our last review was in 2013. So not only have we missed the mark on one, we have missed the mark on two things required by law, by state law and our own ordinance. A great question was asked by a commissioner in that meeting. If they did not have the tools in place, how could they correctly do their job? Not only is that a great question, but has our county unlawfully been moving forward and making decisions without the county's mandatory required by law comprehensive plan? Variances was another topic of the Planning Commission training session. They were described to the Planning Commission as a hardship is defined as a restriction of property so unreasonable that it results in an arbitrary, capricious interference with basic property rights. Hardship relates to the physical characteristics of property, not the personal circumstances of the owner and the user, and the property is rendered unusable without the granting of a variance. A variance may be granted in an individual case of unnecessary hardship if the board makes and explains in writing the following findings. There are extraordinary exceptional conditions pertaining to the particular piece of property. These conditions do not generally apply to other property in the vicinity. Because of these conditions, the application to the particular piece of property would effectively prohibit or unreasonably restrict the utilization of the property, and the authorization of the variance will not be substantial detriment to the adjacent property or public good, and the character of the district will not be harmed by granting of the variance. The hardship is not self-imposed, and the variance is the minimum variance that will make it possibly reasonable use of the land, building, or structure. And when is a variance not permitted? The fact that the property may be utilized more profitably if a variance is granted may not be considered grounds for a variance. I read through this for the reason that this is what should be in our subdivision ordinance, that our planning commission has to go by for approvals, but they're not there. There is no definition of a variance, and there is nothing in our subdivision ordinance of the information I just read. The word variance is only used one time in our ordinances under the authority, which states an existing subdivision plat not recorded in the Lawrence County Clerk Report of Office at the time of adoption of these regulations, and the continuing undivided land whose owner desires to subdivide or re-subdivide must comply with the regulations unless a variance is granted by the Lawrence County Commission. But if you do not have a variance ordinance, it can be considered unlawful to grant one. Here's why, per the South Carolina Code of Laws Title VI, a local governing body by ordinance may permit or preclude the granting of a variance for use of land, a building or structure that is prohibited in a district. And if it does permit a variance, the governing body may require affirmative vote of 2/3 of the local adjustment board members present and voting, notwithstanding any other provision of this section, and the local governing body may overrule the decision of the local board of adjustment concerning a use variance. Our county has approved many variances so far, and And when you look at the developer's variance request in our planning commission agendas, I see no reason for the request given for it. To us, a lot of work needs to be done on the subject of granting variances and how to do it lawfully. Since we have been coming to these county council and planning commission meetings, one statement that we have heard over and over is if these developers follow all the ordinances or check all the boxes the county has to approve them, it would be considered unlawful not to approve them. If they have met all the requirements of our ordinances, well, what if they don't check all the boxes? What does our county do then? I'm going to share a very short version of a personal experience of mine. Through this time, I have really tried to read and learn our subdivision ordinance, and I came across a reporting requirement, which states, once approved, a plat shall be recorded by the subdivider in the office of the clerk of court of Lawrence County within a 12-month period of time from the date of approved grant. After the expiration of 12 months, said approval shall be void. I tried online to find the recording of this approval and could not find it. I made a trip to the county offices along with Ms. Riddle, and it could not be found in the clerk's office, so it was directed to a man named Ray. He could not find it for me. I went back a second time by myself to the clerk's office. It could not be found. I was directed to go to the building codes, and then they directed me to go to Mr. Satterfield's office. I spoke to the secretary there, excuse me, and let her know what I was looking for. And she said she would speak with Mr. Satterfield about it once he was back in the office and call me when she did. I got a call later that afternoon from the secretary with a reply to my question. That no, it had not been recorded, but all they had to do was stamp it again. I replied back what the ordinance said, and she replied back that Mr. Satterfield and the county attorney said they just had to stamp it again. That was the only explanation I got. There was a legal filing on this matter that is absolutely public knowledge. Anyone can go to southcarolinacourts.org and look for yourself. I won't go over any of it, but many issues were found through the Freedom of Information Act, which is also public information once granted. It is really astounding what I have learned how this approval came about, which brings me back to the point. If they are checking all the boxes, you can't deny them. But if they are not, I guess we just stamp them. Ms. Stewart has also made reference to another issue, the Bridgeway development. And now we have a more recent issue on approved subdivision on Abercrombie Road. Due to extensive grading, the construction company has disrupted 2 natural spring beds. That has caused a small creek to dry up and be filled with sand and silt. Some residents have their wells running dry, and a small lake down from the area they started to recede. On a good note to that, some of the residents have been informed that the construction company is going to try to rectify the issue of the water flow, but cannot remove the sand and silt from the creek due to environmental protection. I hope this can be resolved for the residents of Lawrence County in this manner. One more matter that Ms. Stewart has brought up in a past meeting about the developer that is buying up and developing most of our land here in Lawrence County. They want us to believe that they are a Spartanburg, South Carolina-based company that cares about our communities, but we know better. I have a couple of articles here, and I'm just going to briefly read. Somoto, Corners, Key Carolinas lot pipeline with new development deal. 60% purchase of Mark III property secures primacy for Van Ryn Builders and marries with Crescent Communities deal on border building development master plan. And of course, our state and several others here on the East Coast and a couple on the West Coast are all involved in that. Somoto Forestry acquires a U.S. land development company is the other article, and I won't take the time to read the articles. So it's not a company it's a corporation is what it is. It's not somebody that cares deeply about our community and how it's developed. My hope in bringing all these subjects forward this evening will help you understand our positioning and wanting to be reassured that Lawrence County is doing everything possible to provide positive growth and adhere to South Carolina law and Lawrence County ordinances for the protection of all our citizens and our property. If we don't go through this growth and development process correctly, the damage will be irreparable and costly for our citizens and our county. Thank you.
Moving to old business, are there any council submissions, planning boards, commissions, recommendations? Here none, we will move on to second reading of ordinance 929, project arrangement with Orange County Attorney to inform us on the status of that.
Yes, sir. This, they're asking for minimum investment as required by law, which is going to have failure, which this is going to be somewhere in the neighborhood, I think, 16 million. And could be the jobs. We would certainly urge second reading of this. We will make the announcement on the 23rd. Will be public hearing and third reading announcement.
For recommendation of county attorney, do I have a motion to approve 929 for second reading?
Push to approve.
Second by Mr. Garrett. Are there any discussion? Hearing none, I'll call for the vote. All those in favor, raise your right hand. Please signal. Next up, we have second reading on ordinance 930, the Lawrence County Water Sewer Fund. I'll get Lawrence County Attorney gives any updates on this.
Nothing has changed since the first reading. I think Bill is here, the attorney, Foes is here. They have any additional comments. This is just a continuation of meetings that are required by the Enabling Act for their $9 million bond.
Are there any questions, council, for Mr. Fields? I'll call for a motion on second reading of ordinance 930.
Motion to approve.
By Ms. Clark.
Second.
Second by Mr. Carey. Any discussion? All vote, all those in favor, please raise your right hand. 6-0. Next up, we have if you will recall, at the July 12th council meeting, Mr. Carroll made a motion to postpone second reading of ordinance 926 to this meeting. Staff has been diligently working hard on this ordinance. I believe right now it's the county attorney reviewing for consistency in comparison to what has been approved in first reading. In addition, I want to congratulate and thank Ms. Wargo for all of her hard work. She has spent a lot of time and hours working across many department heads trying to bring this to fruition and add some of these things that we've never had in our ordinance with some more protections to make sure we are protecting the county and citizens of the nature more than anything as we proceed through this. That ordinance just is not ready for second reading comfortably. And I'm going to personally make a motion to postpone this 2 more meetings to the September 13th council meeting. Well, second by Mr. Carroll, is there any discussion? All those in favor of postponing the second reading of ordinance 926, September 13th. Council meeting, please raise your right hand. Motion passes. That being said, I would like to have a meeting our committee meeting as a whole of council, specifically one night solely to discuss this ordinance. County Council will serve it weeks in. Worst case person next week, we will have had the opportunity to prepare it for us. And I would like to propose that we meet on the 18th, Thursday the 18th, a week from this Thursday. And basically just have a discussion of all the updates of that ordinance. How does the 18th look for? But I have a major conflict. 5:30. Or is there time to be better than that for you? 5:30. That work? So we will call a committee as a whole, county council, on August the 18th, 5:30 in this room, with the sole purpose of reviewing ordinance 926. There will be no votes taken. There will be no nothing necessarily motioned on, but we will have the open discussion with council members. Opportunity to discuss with staff changes they've made. We see something that we think needs to be different, we'll have the ability to ask and get some explanation. So we'll go ahead and set that action. Once staff has that prepared, so that pack it out so that council and the public have opportunity to review that before they. All right, well, that's all we have for old business. Is there any new business? We will move into county comments. County council comments. I'll start on our right.
I just want to thank everyone for coming out with this case concerning the issue from tonight, and also the VA and the VR for the award that they gave to us, the Great American Award. Thank them and have a beautiful open house as well. Y'all really need to go and visit that building. It's a beautiful facility as well. And congratulations all.
Right.
No comments tonight.
Right.
Thank you, Madam Chairman.
Yeah.
With these ordinances that we're talking about, we subdivisions, I do want us to take time, maybe do it right. You know, I think we need to, and I'm not trying to stonewall anything off, but we really need to take time right. Because it's going to affect this county 50 years from now.
Yeah.
The citizen concerns that were brought up regarding the ordinance, the subdivision, I can attest to every bit of it. I've been working with staff as well to try and get a document that reflects what we need in this county. It's very difficult. There are a lot of moving parts. Every time you get something set, you find there's some requirement, regulation, something that addresses something else. So we certainly appreciate the work that you've done in finding issues that we need to address, and we certainly, I take notes and put those in. And appreciate you. Sorry for the case.
Thanks, sir. I do want to thank Jeff for his hard work as well. He's spent more time in staff than any of us on this particular draft of the ordinance. He's better than me because I just tell him about one and go find it. And then call that man right there and make sure we're legal. But they have been doing great with putting in some restrictions that will definitely benefit the land. That's one of my concerns is that we're in that county. And I hear the Save the Farm. And I think the big things are coming. I want to save the nature. We might still see the houses, but when I see the houses, I want to see big trees left. I want to see something that's more friendly to the eye instead of just houses stacked up against each other. And they're doing a real good job on that as well as density requirements. I believe. I know there were some references tonight to the subdivision ordinance, but it has changed drastically from the 910, which is the most recent one that was approved last December. And I will point out, since we approved 910 in December, there have been 0 variances granted. In fact, there's been 0 requested off of 910. Now, there were some in the previous ordinance, but since 910's approval, there haven't been any variances granted. And of course, we have a moratorium now, so there won't be any granted. The 926, you'll see a drastic change in, and I encourage you, we hope to have that online as soon as it's aired, have the opportunity to review it and provide input. We will, normally during committee meetings, there's not a public comment time period. However, we will allow public comment at the meeting on the 18th for those that have read the ordinance and desire to comment on it. I do want to encourage some comment from the steward on the cemetery concerns, water concerns. Sounds like you're already working with state agencies. There are roles of government. You got federal, state, county, city, and some of the things that are of concern are governed by a power greater than us at times, where it doesn't matter what we think or what we do, we're superseded. And grave sites is definitely one of those things, and that be government or DA. But it sounds like you're already working with archaeological folks in that, and I commend you for doing it because they are the ones that would have to yay, nay, or stop it. As far as access to
records. We have a very open FOIA process. The county attorney's office does a great job. They receive all those FOIA requests and organize, setting up. We have folks that come and review those documents. Sometimes we send them straight to them, whatever their preference may be. I, for one, have always spoken for transparency since day one. So there's documents you need and it's available. And it's legally able to be sent out. I have no problem providing that for anyone if we have it. Sometimes there are things that are requested we just don't have or have never gotten. We do run into that problem from time to time, but if there's ever a roadblock or if you question whether or not it exists, I'll be glad to answer any questions on this existence. I personally have no problem at all, but there's always the formal FOIA process as well. That's all I have. I just want to thank all my council members for the Association of County meeting. I learned a lot. I always enjoy going to those meetings. There's always a care or nugget or two we can bring home and make this county better. So thank you all for joining us there. That being said, that's all I have. I will call for a motion to adjourn.
Motion adjourned, Mr. Chairman.
Second. Okay, all those in favor, please raise your right hand.